Yes, good afternoon. I'm going to look, by way of contrast to the funder warranty, to the purchaser and tenant warranty in the JCT standard form, the first page of which is page 1057, and the substantive provision in clause 1 at page 1063. And in contrast to what we... I'm so sorry.
1063, did you say?
That's the substantive provision. The first page is at 1057.
What is this?
This is the collateral warranty for purchasers and tenants under the JCT standard form.
So this is the one that they replaced with the one that's at 430?
Exactly. And the nature of this type of warranty is a backward-facing warranty of fact, circumstance or outcome. Clause 1, the contractor warrants as at and with effect from practical completion, the contractor has carried out the work in accordance with the building contract, essentially. So the nature of that warranty is characteristically very different from the funder warranty, whose interest is obviously during the execution of the work and in respect of the fulfilment of the performance obligations under the building contract. And so we do say that the JCT standard industry forms juxtapose the two different types of collateral warranty. I would accept that this warranty, the one we're looking at here, is not a construction contract, whereas I say the funder one is. The third topic I wanted to deal with is...
You say this one is not?
Yes, because it's not a warranty to do anything. It's an assurance that from practical completion, which is when the building work has been done, all the construction operations have been carried out, that it meets a certain standard.
But wouldn't that be said against you, that generally warrants to purchasers and tenants are not regarded, not performative, whereas ones to the funder are expected to be performative, whatever that means? Well,
with respect, no, because in this case we deliberately, the parties agreed not to use this form.
Which parties agreed not to use this form?
The contractor agreed to it because he subscribed to a building contract which mandated that he would sign a collateral warranty in the form that the bespoke form that was agreed in advance. So, under the building contract, it's clause 7C, page 319 of the bundle. So we can look at that now. Page 319. Is clause 7C. And by that provision, I need to remind ourselves this was amended at page 395, but where clause C is stated to apply, the employer may, by notice, identifying the purchaser or tenant, require the contractor to enter into a collateral warranty, and there where it says in the form CWA P&T completed, those words were deleted and replaced with different words, which are at page 395 of the bundle.
So, sorry, what we're looking at is the standard JCT form, is it?
Indeed.
.395?
Yes. And at 395, you will see an amendment to clause 7C, in which instead of the P&T rights, it was to be the form appended at Schedule 5. and the format Schedule 5 is materially the ACW that was in due course signed.
This is another contract that takes the form of a sort of bewildering list of minor differences from the JCT standard form. I'm sure it's terribly easy for practitioners to use, but it just causes terrible headaches when it gets to court.
I'm sorry. I'm very sorry for that.
Provided any kind of consolidation for our use? What the contract actually said.
The best place for that is in the judgments in the Court of Appeal.
Yes.
They do recite 7C as amended. And so,
But if we want to look at some other clause, it's...
I don't think you will. I hope you won't need to delve too far. But my point is, I hope addressing my Lady Rose's point, that there was a deliberate decision here to use a form of a particular type, which I would parenthetically say characteristically looks much more like the funder agreement than it does to the purchaser and tenant warranty of the standard form.
But are we allowed to take into account that kind of deletion or replacement?
I'm not. This isn't an exercise in construction. I used the two options given by the JCT because I hope they inform the court of the different types of collateral warranty that the JCT, the standard body, uses, and I submit that they fall on each side of the line of what is a construction contract for the purposes of Section 104.
And we don't, I suppose, know what the standard forms were at the time when the Act was passed, do we?
In terms of collateral warranties,
yes.
I don't, I'm afraid.
We do know, don't we, that the collateral warranties were then commonplace by the time the Act was passed, because of Murphy and Brentwood.
Yes. But I'm not sure that they even had them, but I'm afraid I'm reaching into some dark recesses of recollection. But the point is, this I hope now leads into my next topic.
There's an oddity that in the JCT's commentaries on these two forms, explaining what the clauses mean, precisely the same words are used to describe Clause 1 in both cases. This confirms that the contractor owes the same obligation to the purchaser or tenant or funder as he owes to the employer under the building contract.
There you go. Perhaps one can't get
I'm not sure.
Commentary. But conceptually, looking at the structure of these agreements, viewed in light of the distinction that Lord Justice Stuart Smith made, which is the appellant's case, I say there's a huge and significant difference between the two.
Yeah, but what they didn't do was include the word undertakes, which
Certainly,
seemed to be what Parkwood was pointing as being the key point.
I will certainly address that. I'm coming down the list there. I really did want to emphasise this point because it leads where we are now. My third point was the interconnection between the building contract and the ACW. You can see that the obligation to provide the collateral warranty exists in the building contract, and therefore there's a close proximity between these two contracts. We deal with that paragraphs 46 to 48 of our written case, where we make the point that the provision of warranties was therefore and should be regarded as an integral part of the overall consideration for the building contract and for the project. In other words, as part of the promise of payment to Simply under the building contract, Simply had agreed that it would enter into the ACW. Without the developer knowing that it could in due course provide satisfaction to a prospective purchaser or funder or tenant, it's quite conceivable that many projects wouldn't go ahead. They're part of the package of confirmation that any third party will want, understandably in light of Murphy and Brentwood. So we would respectfully submit that the obligation to provide the collateral warranty in those terms is every bit, of course, as primary as the obligations owed to the employer. And in our submission, they are therefore a composite suite of documents which interact with each other in a conceptual way. I'm going to break now and allow Mr. Owen to take you through a couple of other, or three other provisions within the building contract. Crossover.
Just before you do, can I ask you to think about something while you're temporarily sitting down? Which is this. We were discussing with Ms. Day this morning how, in many respects, the beneficiary under a collateral warranty suffers the slings and arrows of fortune that affect the building contract, so that if it's varied between its parties, then that affects what they get under the collateral warranty.
Yes.
And if there's a settlement of a relevant issue, that may affect what they get under the collateral warranty. That may be subject to exceptions if it's to do with damages or loss. What if, under the principal contract, the parties have a string of adjudications on their way towards practical completion, none of which are later appealed, and under which the paying party pays up, i.e., which become, I can't remember whether it's a statutory feature over time or just in practice over time, effectively binding as between the parties to the building contract.
Effectively, it's not mandated within the limitation.
Within the limitation.
In your claim.
So, nonetheless, de facto, money's been paid, nobody's going to raise it. Does that flow through to affect the beneficiary under the collateral warranty?
No. As is revealed by this case, adjudication is a private right between the two parties to the construction contract. So adjudication decisions are separate, and in this very case, Mr. Vinden, the adjudicator, produced two separate decisions. He happened to reach the conclusion, perhaps unsurprisingly, that the contract was a breach.
I accept that, of course. I don't mean it directly affects, but I mean under the same principle that the collateral warranty beneficiary gets affected by what happens under the building contract.
He gets affected. There's an obligation. Well, if there was a, depends what the dispute was, of course.
Well, give me an example. Suppose that there was a dispute about whether a row of windows in a certain part of the building needed to be double glazed or not. So they went to adjudication on it, and the adjudicator said no.
Yeah. So that would be a
beneficiary then come back and say, oh, well, my reading of the building contract says they did, and I want compensation for the fact that they're not double glazed.
Yes, if he was able to, because it would be a question of contractual well, that's an interesting question. The obligations, the obligation to perform in accordance with the building contract, there might be an argument that the contractor can say he has, as between him and the employer, been treated as having fulfilled that obligation by virtue of the adjudicator's decision.
Yes.
It's possible. I'm not sure.
Well, don't worry to answer now. I really just gave it as a think topic.
Yeah, I don't think it ultimately bears on this appeal.
Okay.
Well, it does in the sense that what does it mean to say the contractor owes a direct obligation to Abbey to perform the work as described in the contract? What I think we're all struggling with is what does it mean when you say that? If it doesn't mean they have to pay for it, it doesn't mean they can affect it.
They have to fulfil. I'm so sorry. They have to fulfil all their obligations under the building contract. Payment is a different topic, which I can address you on, but the contractor has to fulfil all its obligations under the building contract. The fact that under this document, those obligations have been defined in shorthand by reference to the content of another document doesn't stop it being an obligation owed to Abbey. And it's simply about what...
But if there's an obligation X in the building contract, which the contractor and the employer agree by way of variation to remove from the building contract, then Abbey can't sue on it.
That is right.
And they can do that by way of agreement of variation. They presumably could do it by way of settlement of an issue as to whether it's included at all.
There may be provisions as between the purchaser and tenant and the employer that stop him doing that, which we haven't got insight into in this case. And one would expect something along those lines.
Yes.
The reason I was slightly querying my Lord Bridges' question is because of the temporary status of the adjudicator's decision.
Yeah.
It might be a different story if, for example, a judge had ruled on the proper meaning of the provision.
Yes.
And that might be a different type of situation.
Thank you.
Thank you.
Now, Mr. Owen.
Lord, if I could just add to that point. In terms of adjudication, it's temporarily binding as between the parties to the construction contract, such that one cannot re-adjudicate the same matter that has already been determined in an earlier adjudication.
Yes.
But that principle applies as to the parties to the construction contract. If there are two construction contracts, there is nothing in principle that would preclude the revisiting of that as between the different parties. So yes, there could be an adjudication decision as between Topan and Abbey, between Topan and Simply, which concludes that it should have been double glazed, but it would be open to Abbey under a party to a separate construction contract to revisit that in the context of their construction contract. It wouldn't bind as it would with the subcontractor. It doesn't bind down the chain as it would with the subcontractor. There are separate construction contracts. So,
well, then the point that Lord Justice Coulson made about how convenient it is to have adjudications all in the all being adjudicated, or disputes all being adjudicated, might operate in the opposite direction, because actually you then do get serial adjudications of the same point by all these different funders and purchasers and tenants who have, if you're right, their own right to adjudicate the same point.
yes, and that is a risk and a feature of the Act, insofar as there are separate contracts. One of the trade-offs for it being a temporarily binding right as opposed to a finally binding right is that it binds those parties to that construction contract on a temporary basis. There's nothing to stop those parties resolving it on a final basis as between themselves in court or arbitration, nor is there anything to stop a subcontractor or parties down the line having the same dispute argued under their separate agreements. That is the nature of how the regime...
But if they have generally separate agreements, a subcontract is a separate agreement.
Yes.
But here it's just a promise to perform what you promised to perform.
Well, it's a separate contract entered into on its own terms. I mean, we would have to say that there are two construction contracts here. One, the building contract, and the other, the ACW.
Yes. But if the day before they were due to get their double glazing adjudication, they settled the claim,
Yes.
why wouldn't that settlement operate pro tanto as a variation of the building contract and therefore a variation of the obligation contained in the collateral warranty?
Yes, I think the answer to that is it might well operate as that, but the value of the right of the beneficiary under the collateral warranty is not the same as the rights and obligations in the building contract. As we've seen, the beneficiary itself does not have the power to change the works as are binding upon simply to perform for Topan. But that doesn't mean that there are not two separate construction contracts. It doesn't mean that the right under Part 2 doesn't apply to the second. We say, on the contrary, it does. I'm conscious I'm diverting slightly. Could I just address the court briefly, please, on the three clauses? Mr. Nissen has referred to the close connection between the Abbey collateral warranty and the construction contract. And we say that when construing, as a matter of interpretation, the warranty, one must bear in mind that close connection, because the building contract confers specific rights in Abbey, which through the ACW are given privity and their mechanism for enforcement. And we say it's a useful test to see which side of the line it falls. On the one hand, if these obligations under the building contract are self-evidently of a character which are intended to be complied with at the time and implemented during the currency of the works in favour of Abbey, that is indicative of performative obligations and corresponding rights which are capable of being enforced contemporaneously. If, on the other hand, those obligations under the building contract in favour of the beneficiary, Abbey, were primarily concerned with simply a fact or a quality as to the end product, that is indicative of a warranty of the type that Lord Justice Stuart Smith envisages. And there are three in particular that worth further attention. First is clause 2.6. This is page 285.
Sorry, 200?
285, my lord.
Thank you.
Clause 2.6, and for the court's note, it is amended at page 383. Clause 2.6, which is at page 285, deals with work not forming part of the building contract. And with the amendment, it would read as follows: in regards to any work not forming part of this contract, which the employer or beneficiary requires to be carried out by the employer himself or by any employer's person or beneficiaries.
Sorry, where do you go?
Yeah, where is beneficiary?
Yes, sorry, this is by amendment 383, my lady.
Oh, I thought you were telling us to look at 285.
Yes, 285 amended by 383 adds the references to beneficiary.
383.
383.
Oh, I see. So then you have to go back to 285.
Towards the top of 383 is an amendment to 2.6.
Do we need to worry about the operative part of 2.6?
So what,
Starts to get quite complicated.
No.
where do the words the beneficiary get inserted in?
Yeah, so if you go back to 285, it is a little confusing. 285, 4 words before the end says employer requires. It should read which the employer or beneficiary requires.
But I thought we decided that the beneficiary can't require them to carry out any other work, that they're
Ladies.
bound by the
That's
terms of the
the
building
appellant's case.
No, but I thought it was common ground that that Abbey can't say to simply, please double glaze all the windows, when that's not part of the building contract.
Well, it's a slightly different point. Indeed, there is no right in the beneficiary to change the works, capital W, as required. What there is a fresh right to allow the beneficiary to do works of its own, either by itself or with its own third-party contractors, during the currency of the work. And the importance of that is that once the contractor assumes possession of the site under the contract, he has exclusive possession to all others, and the beneficiary would not have that right to carry out its own works during the currency of...
Sorry, I'm not understanding. So you're saying that Abbey might enter into a separate contract with simply to carry out different work on the site?
Or any other
building contract?
Or any other contractor. So, for example, if Abbey wanted there to be showers in all of the bathrooms and the building contract didn't provide for showers, this provision allows simply to go to another plumber, the third party, and get them to install the showers. Abbey, it allows Abbey to do that.
Sorry, say that sentence again then with the right people in it.
Yes. So let's assume the obligation is to put in baths in all the bathrooms.
Yeah.
That obligation is...
What obligation? Under the building?
Yes, under the building contract. There is an obligation for the contractor simply to do particular works as defined under the building contract. Let's assume those works are to put in baths only. There is no right in Abbey to have its own contractors come in during the currency of the works and install showers. That is because simply enjoys exclusive possession of the site during the building contract. What clause 2.6 does, as amended, it gives a specific right in the beneficiary, Abbey, to require to be carried out during the currency of the works, the implementation of the showers, and that can be with...
but not by the contractor.
No, by its own
Just
persons.
require the contractor to let in Abbey's other contractor
Absolutely right.
to do those additional works, subject to the conditions set out in sub 1 and 2
Yes.
about whether the employer's requirements make that.
Yes, that's quite right.
Sorry. I see. So this is Abbey has a right to require simply to allow in shower installers of Abbey's choosing.
Yes. During the currency of the works, which it would not otherwise have, because the contractor enjoys exclusive possession of the site.
Yeah.
So why does this help us?
Yes, quite. we say, and there's two other examples which I'll come to
So then
briefly.
do they have to have both showers and baths then? Or what if there's only room in the bathroom for one? No, that's not a flippant question because if they're going to install a shower, then what if then that precludes simply from installing baths?
Yes, to the extent there is any prevention on the ability of the contractor to carry out the works, and that would not apply. As between Topan and simply, i.e. the parties to the building contract, the works are as defined, capital W, in the building contract. The significance of this, my Lord, Lord Hamblin asks, is we say this is a valuable right, exercisable or intended to be exercised during the currency of the works themselves, i.e. obliging contemporary or contemporaneous performance, and if necessary, timious performance. It's not concerned merely with the quality of the work as an end product. It confers the opportunity and the right to have work done at a cheaper cost during the building contract.
But non-contract works.
But non-contract works, quite. Indeed, it's conceivable that refusal could render impractical or impossible the subsequent execution of those separate works and the realisation of its benefits. And we say that it reveals the significance of the beneficiary's rights under the ACW to have construction operations carried out, rather than in merely obtaining a promise as to their quality. There is an inherent connection.
You could have that. You could have that contract without the collateral warranty. It's completely separate from the collateral warranty.
There would be no right of the beneficiary to have those works undertaken during the currency of the main contract works. It would not have any lawful access to the site. The contractor enjoys exclusive possession.
Yes, but there's nothing that the beneficiary could have this right. This is under the. Aren't we looking at the building contract?
Under the building contract.
Yes, so they could have this right, even if Topan had not asked simply to enter into the collateral warranty with Abbey.
Yeah, there would be an issue as to enforcement there and privity.
Yes, I'm going to say, because does this pop up again in the collateral warranty?
Yes.
Oh, it does.
Well, insofar as clause 4.1 we say provides for it, the significance comes on privity of contract. The ACW is the mechanism, the precise mechanism by which privity is obtained by the beneficiary.
Yes.
It becomes a significant point, we say, when you are construing as a whole what this warranty means under clause 4.1. It is inherently linked to the building contract.
So you're saying that if there was just this adding in the beneficiary to have the showers installed as well as or instead of baths, then that would be unenforceable by Abbey, but somehow entering into the collateral warranty, by which simply promise to install baths, enables Abbey to make them install showers.
No.
It just they have an obligation under the building contract to let in a contractor to put in the shower.
That's as far as
that's an obligation which is caught up within the compendious words of the collateral warranty.
Yes, quite right.
Yeah. Not quite sure what it tells us about the answer to the big question, but
confusion has arisen due to a peripheral debate as to whether injunctive relief could be obtained and the difficulty of that. And we accept, Mr. Nissen will deal with this in greater detail, we accept that it may be difficult to obtain relief, although we say that is overstated. The point is not how difficult it is for the beneficiary under the warranty to obtain equitable relief, or indeed anyone, because the same difficulties would apply under the building contract for the employer. The point is about locus. In terms, Lord Justice Stuart Smith's reasoning and his rationale for interpreting these provisions as a mere warranty. He says in terms that there cannot be any locus to seek relief, and that is paragraph 129, page 210. And that reasoning is central in construing the underlying right and cause of action in the narrow sense of a mere warranty.
So what you say is that Abbey could get an injunction stopping, well, a double negative, stopping
a prohibitory injunction
some
preventing
contractor of Abbey, stopping the contractor prohibiting entrance by Abbey's shower fitting contractor.
Quite, yes. And we say that analysis from Lord Justice Stuart Smith runs into conflicts when one is checking the rival iterations. The question of contractual construction here, fails to give sufficient weight to the scope and the nature and the purpose of these underlying rights, and their being actionable during the currency of the works.
Yeah.
Significant feature, of course, of construction adjudication is that it allows referral at any time, i.e. during the works, with a rapidly obtained legally enforceable decision. It is itself a contemporary remedy. My Lord, just for the court to note in a view of time, clause 235 is page 292 as amended by 386. So clause 2.35, 292, and it's amended 386. If I could take the court finally to 294 is the bundle.
What about?
So what clause on 292?
Yes, so 292, my lady, is the amendment to clause 235, 2.35.
2.35?
Yes.
No, you said 2.
This is another one.
This is
92 as
there are
amended
three
by
terms.
386.
Yes. Yes, there are three terms. The second one is clause 2.35, and there are two relevant references. Page 292 has the clause.
That's the unamended, the pro forma.
Yes, my lady, the unamended version. And it, in short, is a term that requires defects during the rectification period, which is the 12 months following practical completion. It requires those to be carried out. And at page 386, there is by amendment an obligation on the contractor to use all reasonable endeavours to eliminate any disruption to the beneficiary in carrying that out. I'd like to draw the court's attention briefly to clause 3.1, which is at page 294.
Sorry, 394?
Yes, 294.
294, I'm so sorry.
Thank you. The amendment is at 388. And it is, as the first example, that you add in after or employer to read or any beneficiary. That is the extent of it. So at 294,
Sorry, which clause are we in?
clause 3.1, my lord. Clause 3.1 provides for access to the works. The employer's agent and any person authorised by him, or the employer, or the beneficiary. This confers a right in a person authorised by the beneficiary to have access to the works at all reasonable times. It is not access to the site, capital S, it's access to the works. So it gives not just access to land, but to that which is being carried out. And the purpose is to permit inspection of the works during their currency. And again, we say the value lies in the contemporaneous enjoyment and vindication of those rights. A claim for damages for breach of warranty would be redundant. We would say also that clause 3.1 supports the respondent's construction of clause 4.1a of the warranty, and it complements its wider terms. Clause 4.5 of the warranty, which is at page 432. It includes a term as to the use of materials. Suppose the contractor were to use asbestos. The contemporaneous exercise of the right under clause 4.1a of clause 3.1 of the underlying building contract enables the contemporaneous discovery and enforcement of the right. And again, a remedy of damages after the event is of little utility or comfort. My lords, my lady, I hand back now to Mr. Nissen.
Thank you. Having the break enabled me to find paragraph 6 of Lord Justice Coulson's judgment gives you clause 7c in its full and flowing amended form. If it would be helpful to the court, we would be happy to provide the clauses that Mr. Owen has referred to in their amended form.
I think we can probably manage just with those few.
Yep, thank you. And just to pick up on, Lady, I don't want to spend a moment longer on baths and showers, but the suggestion was not taking out baths and putting in showers. The obligation to put in the baths remains. That's part of the building contract. This is allowing in additional works not forming part of the building contract.
Yeah.
My lady's point was if there wasn't space for the baths, so that the requirement to have showers interfered with that main contract obligation.
Then that wouldn't be a request that was capable of being complied with. So that would be the end of it. All right. So now return. So the point is that the Third Party Contracts Act is excluded under this act, under this contract, under the building contract. Therefore, by definition, the only route by which the beneficiary can avail itself of enforcing the provisions that Mr. Owen has referred to is using clause 4.1a.
Where do we get that exclusion from?
It's clause 1.6, I think, of the building contract.
Sorry,
Clause 1.6 of the building contract. My memory serves me right. Page 281, but that is itself deleted and substitute. The substitute clause is at page 380. Unless expressly stated otherwise, nothing in this contract confers or is intended to confer any rights under the Contract Third Party Rights Act. I wanted to move then, please, to. Oh, sorry.
I see, but you wouldn't construe putting the beneficiary deliberately into it as indicating that for those clauses, the third-party contracts.
No, there has to be an express conferral. So, for example, you have to make a specific provision, save in respect of clause 8 or clause 7, and so on. Any argument that there's an implied conferral is not sufficient. Moving then to the terms of the ACW, which is at page 430, which is my fourth topic, clause 4.1a, the contractor warrants the contractor has performed and will continue to perform diligently its obligations under the contract. We submit that what is promised here is both past and prospective, and as both the majority agreed in the Court of Appeal, is a primary obligation owed to Abbey. That's Lord Justice Coulson at paragraph 62 and 63, and Lord Justice Peter Jackson at 158. It is the key obligation, just as would be owed to the funder under the JCT warranty. It is of no consequence that the scope of the obligations is defined by reference to another document. That does not mean it simply is not providing direct obligations to Abbey in respect of it. On a question that was asked, I think, in relation to repudiation by my Lord Briggs, the duty is, we submit, to perform the obligations under the contract so long as those obligations persist. So whoever it may be that...
Under the building contract?
Yes. If those obligations come to an end, who's ever responsible for repudiation, that brings to an end that, but obviously accrues rights up to that point. In short...
Is that what is meant by the last words of 4.3 then?
Yes. In short, as the Court of the Majority held, simply could not fulfil its obligations under the ACW without also performing its obligations under the building contract. The direct obligation under the ACW was inextricably linked to the carrying out of construction operations.
So on your case, if it didn't have the words "and will continue," would it make a difference?
If it was "has," that would be an indicator, but it wouldn't be conclusive. But the fact it has the words "will continue" emphasises the performative nature. The reason why I'm not focused solely on the word "has" is because it may be that there are other provisions which make clear that it's intended to operate from a retrospective point. So one would have to read the whole agreement.
But you contrasted this with the funder agreement, and the key to the different funder pro forma was that it referred to the fact that the obligations only kicked in when the works were complete.
No, that was I contrasted it with the purchaser warranty. The purchaser warranty did that. The funder agreement was I compared it. This was parallel. That's the point. The funder is always interested in the currency of the work. Right. The conventional purchaser or tenant is sometimes concerned only with the end product.
But suppose on page 431 there had been an additional D that said the contractor has completed the works for the satisfaction of the employer, or practical completion took place 3 years ago.
Well, if it was a backward-looking, obviously one has to construe all the provisions, including the recital, but if it was a backward-looking warranty that was therefore simply a warranty as to the outcome after the building works had necessarily been completed, I would accept that's not a construction contract. Because it's not a contract
right,
for
but the fact that the works had all been completed by the time this contract was entered into
was immaterial. And is not, that decision is not challenged, because the terms of the contract made clear that it was to be treated as having been referable back to works that had not been carried out.
Terms of which contract?
So the language of the ACW made clear that it was intended to have effect from the date on which any works were carried out pursuant to the building contract. That's clause 4.2.
4.2, sorry?
4.3, apologies.
Well, no,
Sorry,
that-
which
no, that's
4.3?
really talking about the building contracts, not talking about this.
Yes, well, the works are never going to be performed independently under the ACW. By definition, whenever they were performed, at whatever time they were performed under the building contract, they would be captured by this ACW. And the date of execution made no difference.
Can I just, I think this is your point 5, when you were telling us what your points were going to be.
It is.
I mean, just on point 4,
Yes.
so just leaving out the timing of the execution of the agreement, which is a point I would wish to hear you on, just to understand what the position is there, as my lady was asking. But just on point 4, the terms of the agreement, leaving aside, supposing this warranty agreement had been entered into a month after the building contract itself was entered into. So you're just taking us to the points that indicate this is a direct obligation of future performance. So you rely on the 4.1a, the will continue to perform diligently.
Yes.
That's your sort of first point there, isn't it?
Yes, it is. And then we say, submit also that clause 4.1b and 4.1c all envisage carrying out and completing the work. And we refer to that, and they are equivalent to provisions under the building contract. Clause 4.2, we refer to that in our written case. We refer to and rely, we've had this discussion already, the reference to obligations under this agreement, not merely being liabilities. I know my Lord Briggs challenged that as a point, but the reason we think it's important, respectfully, is that Lord Justice Stuart Smith felt, and I give you the paragraph references, 109 and 138.3 in his judgment, he thought that another provision that didn't include the word obligations was significant for its omission of the word obligations. He said, well, that shows that it was a warranty of fact, circumstance, or outcome. But when it comes to his analysis of clause 4.2, at paragraph 118 of his judgment, he ignores the fact that that clause does include the word obligations. And so we submit that clause 4.2 is important because it emphasises the prospective nature of performance. Clause 4.3 and 4.4, again, we say it's relevant that it's concerned with duties, plural, under the ACW, concerning the carrying out of construction operations. What duties, we would ask rhetorically, are there if it is simply a warranty of fact, circumstance, or outcome? Our submission is that these are positive duties. And clause 4.4 is also concerned with obligations. Clause 4.5, a past and continuing obligation not to use prohibited materials. If this was a warranty of fact, circumstance, and outcome, a party in the position of Abbey would only have a remedy in damages for the inclusion of asbestos in the works, and would have no contemporary right to enforce the claim not to use prohibited materials. Clause 5 and 6, Lord Justice Stuart Smith felt it was of significance that these clauses included the word shall in contrast to the word warrant in paragraph 4 as imposing a positive duty, whereas the word warrant did on his analysis.
Which ones? Where's shall?
Shall is at 5.2 and in copyright 6.4. And our submission is that that distinction is unremarkable, and those words do not inform Clause 4. That is because Clause 5 and 6 do not depend on the building contract or obligations within the building contract. They operate outside it.
6.4 is just an exclusion of liability.
Yes.
I don't think that helps you terribly, does it?
It's
not a performative thing.
No, sorry, I'm not relying on it.
You're not.
I was deep.
Oh, forgive me. Yes, you're not.
Justice Stewart-Smith.
No, but I see.
This was an important point, and we're saying no, it isn't. Then Clause 7, step-in rights.
I think he may have been relying on 6.1 hereby grants, but no doubt the same point you make.
Yeah. Step-in rights. Interesting, my learned friend raised this because it was not in any of the submissions below, and it's not in the documents for the purposes of this appeal. It doesn't make a mention at all. The Court of Appeal do not consider.
I think it arose out of something the court asked.
I accept that, but that was by way of question. It was but Malone Friend took the opportunity to say it supported her position rather than simply to answer the question. Our submission is that this is a neutral clause. They're common clauses to enable funders, particularly, to step in and protect the value of whatever funding they have committed themselves to so far. It's neutral in the sense that if Clause 4 gives rise to a construction contract, then Clause 7 is of no interest. Conversely, we don't submit that Clause 7, the existence of Clause 7, can turn that which is not a construction contract into a construction contract. So it's neutral in that sense. But I do rely on it in at least, if it's to have some weight rather than neutral, I would submit it assists us in this way. It shows that the parties did not intend that the beneficiary, Abbey, would be at arm's length in all circumstances. Because it recognised that at least in certain circumstances it could step into the underlying building contract as employer, assuming direct rights thereunder. In other words, Abbey was never seen as an arm's length recipient of an end product, the quality of which had been assured by a backward-facing warranty. It simply recognises that we had the potential, at least, to be involved concurrently in the work. But the difference here is that when you exercise the step-in, Abbey would have to take on the responsibilities of the employer, including payment. So it's a different batch of rights. But we, in the end, we don't respectfully submit that Clause 7 changes the dial. We've contrasted the contract of the ACW with a contract of guarantee. I'm not going to say any more about that. We've given the reference.
As far as the assignment clause is concerned, Clause 8,
yes,
Abbey can assign this contract to somebody else without reference to simply.
yes.
And I think that this contract goes on for 12 years,
Yes.
and it can that assignee can assign to someone else.
Yes, you need consent on subsequent occasions, I think.
Really?
So 8.1, the first assignee may assign the benefit without consent. The benefit of this agreement may not be signed further without prior.
So you can have two assignments.
You can have two assignments.
Exactly. Yes, and that's not.
And for each of those, if it, say Abbey assigned this and someone else, would it still be a construction contract because that person 6 years later could have forced simply 6 years earlier to let the shower installers onto the site?
One recognises that itself may not be a particularly contentious question at that point in time, but the right to adjudicate exists at any time and for the duration of the limitation period. So perhaps in in that particular context, a subsequent assignee might be more interested in the existence of defects. But it's possible that there may be assignments during the course of the why in principle that couldn't happen. And were that to happen, what is clear is that simply couldn't object to that assignment to allow the contemporary enforcement of the showers. I'm now moving to retrospective and prospective.
Just before you do, was there anything in what Lord Justice Stuart Smith says in this area? I think it's really between paragraphs 109 and I suppose 113 that you wanted to, in particular, say about. I mean, this is where he draws the distinction between a direct obligation to do the work and a warranty of the performance of the work owed to the employer.
Yes. Well, I have covered it in some places. I think I will get to it again in others.
That's fine.
The key point is that we don't respectfully accept that one starts with the proposition that the warranty is only of the product guarantee type. The word warranty is broader than that. One then has to look at the content of the promise to see that which is being warranted, which is a product. I think he self-determines the question, I think, in paragraph 111, respectfully, where he says in the third line, it is therefore necessary to focus intently upon the precise terms of what simply construct warranted to be true, which rather assumes what is in issue in this case. But he recognises, in principle, that a collateral warranty can involve the owing of direct obligations to the beneficiary. I think
maybe, I may be wrong, but maybe the nub of his reasoning is the sentence about halfway through that paragraph. This, that's 4.1a, is a promise in relation to simply constructs obligations that are owed to someone else and not to Abbey.
And insofar as he reaches that conclusion on a question of construction, he was in a minority.
I agree.
Insofar as he's saying that question about whether it's owed to a third party is a consequence of all warranties, we would respectfully disagree. It all depends on the wording.
Right.
We say on the proper construction of the provision in clause 4.1a, the majority were absolutely aligned. Prospective and retrospective, everybody has agreed that the proper construction of the ACW was that it was intended to govern conduct occurring before its execution, and that makes the date of execution not determinative in this case. The three paragraphs in the Court of Appeal judgment on that, paragraph 71, recording my learned friend Mr. Gregorio's concession, paragraph 164, and paragraph 188.
Sorry, everyone has agreed that it was intended to govern conduct occurring
before it was executed.
Well, I mean, inevitably, before, yes.
Well, it had been.
It would have to, because there was nothing to do after it was executed.
Well, exactly. But that had been the point at first instance. That had been the
Well, I appreciate that. I mean, the thing I find a little bit puzzling about this is that you get a collateral warranty agreement which is executed some considerable time, not only after practical completion, but after remediation works, in circumstances where I think it's agreed there's nothing more to do under the main contract. So when you then look at the collateral warranty agreement and you try and construe its terms, in the light of the fact of when it's been executed, it's quite difficult to see why it's doing anything other than warranting what has been done.
But because, as I think Lord Justice Coulson and I think also Lord Justice Jackson said, what you can't do is reward the indolence of the contractor for dragging its heels.
Well, hold on. When was the contractor asked to give this warranty?
I think in this case, after...
Well, there's no dragging of heels.
Well, not on these facts, but the
well, other facts, the court might say, well, it must be deemed to have been entered into at the date when the contractor was required to enter into it.
So the position is on retrospectivity that the and this isn't a point.
I understand that.
That's being raised.
But I'm just trying to understand the
yes.
point.
So one has to look at the terms of the agreement. It may be that the date of execution is relevant in a given case on a given set of terms. It wasn't the Court of Appeal's decision that the date of execution is always irrelevant. It depends on the terms of the contract.
Can I just ask, this was argued in the Court of Appeal, was it?
Or was it conceded? Faintly. It borders between faintly and not really, I think.
Okay.
I think it's
right.
the third issue as it was defined.
Yes, that's right.
Appeal. I wasn't there, but you'll get...
Why is it, where is it that, you say one has to look at the terms of the agreement, but what are the terms of this collateral warranty that point to the fact that it's irrelevant that it was entered into a long time after all the work had been carried out?
I'm so sorry. What is it within the warranty that points to being prospective in character?
Why is it that you say that, looking at the wording of this warranty, that shows that it's irrelevant that it was executed after all the work was carried out, when one is considering this point about whether it's a contract for future work or whether it's just a guarantee of past work?
Because it says the contractor has performed and will continue to perform.
But
I mean, the whole of the Court of Appeal were agreed as to this.
Yes.
And my learned friend is not challenging this proposition.
No, but this court gives permission to appeal on the basis that this is a point of law of general public importance. So.
Yes, and with respect, because my case is this was always a routine question of construction, obviously. And not about the meaning of the Act. I'm in a slightly, or was in a slightly different place in our submissions in relation to that. I'm just conscious I have got quite a bit to cover on what is within the written case.
okay.
All I can do, I think, to save time, is to commend the passages, unanimous passages of the Court of Appeal on this point to you.
Right. I mean, I think it's fair to say Lord Justice Stuart Smith took the position, well, this is the sort of warranty he's talking about, so it really doesn't matter when it's executed.
Yeah.
But I take your point that the point is not pursued before us.
Yes.
It leaves a bit of a question mark, that's all.
Yes. What Lord Justice Stuart Smith does do is to say, well, the expressions of prospective obligations have another justification to them. And he deals with that at paragraphs 112 and 124. He says that the past and future expressions were merely necessary to make clear that the ACW covered all the obligations under the building contract, whether they arose before or after execution of the ACW, and because it wasn't known when the warranty would actually be given. That's not a date of execution point in its pure form.
Yeah.
And we've given our reasons. We say there are really 5 points in relation to this. First, the future promise was the key point in Parkwood at paragraph 28, which contrasted a promise to carry out works, construction operations, with a case where all works have been completed. In other words, that which was warranted was not merely a past state of affairs or retrospective, or that works had reached a certain standard. So Mr. Justice Aikenhead was influenced by the prospective language. Parkwood it is common ground was correctly decided in principle. So we see a tension between Lord Justice Stuart Smith finding a difficulty with this and his acceptance of the decision in Parkwood. Lord Justice Stuart Smith also thought that the prospective language was relevant because you didn't know at what point during the currency of the building contract the demand to execute the warranty would come. If one goes to Parkwood, I'll just give you the reference, it's page 868. Article 10 of the building contract in Parkwood also allowed the demand for the collateral warranty to be provided from time to time. In other words, it was entirely unscheduled as to when it would be required. And yet that was not thought in that case, which itself is approved by Lord Justice Stuart Smith, to have been a material justification for the prospective language. In that case, the collateral warranty was sought well over a year after the works had commenced.
This is Parkwood, is it?
Yes.
But before they were completed.
But before they were completed, exactly so. But my point is that the justification for the future language wasn't material to Mr. Justice Aikenhead. Our second point is that what matters is that the whole scope of that which is performed under the building contract is covered by the ACW whenever that work was done, and clause 4.2 does the work of justifying that. That timing point, in other words, that whenever the work was done under the building contract, trumps, if you like, the need to distinguish between work pre and post the execution of the warranty.
You would need that if the warranty is, for example, that the drains will work and the drains don't work, then you don't want to have to prove at what point there was a mistake in the workmanship that caused the drains not to work. What's warranted is that the drains work and that warrant is broken regardless of when the mistake in building the drains was made, whether it was before or after the warranty exists.
No, with respect, what is warranted is the performance of the obligation to build the drains. That's the carrying out that is warranted in accordance with the terms of the building contract.
Well, to build them without defects.
That's also, but it's not the achievement of a result, it's the performance of the obligation. That's the central proposition. The cause of action on Lord Justice Stuart Smith's analysis of what constitutes a warranty, the cause of action for the breach of warranty, this is my third point, must accrue at practical completion under the building contract. So the scope of obligations under the building contract which are warranted on his analysis must necessarily be unaffected by the date of execution of the ACW. By practical completion, all the obligations under the building contract will have been performed, and so the prospective terminology is irrelevant. So it's not a reason, we submit, that supports his position. And the more conventional way to address the timing point is what we've seen in the JCT standard purchaser warranty, which is to warrant from a fixed point in time after the works have been completed, and that's not what these parties chose to do. I want to now move to the absence of express adjudication provisions, which is my sixth point. Lord Justice Stuart Smith thought the absence of express provision was important. That's paragraphs 125 and 142. And our written case in relation to that is at paragraph 76, 1 and 76, 2 and 3. I won't dwell on that, but this, in our submission, becomes circular reasoning. Parliament has determined and decided that if you have a construction contract and you don't put a contractual provision in by express terms, it is implied. And so if you have entered into a construction contract, you are deemed to have had the implied intent to adjudicate. And so, of course, one can always say, oh, well, the parties could have done this or they could have done that. The fact is they didn't. But that, one simply has to look at what the consequence is in terms of, it doesn't assist in the resolution of the question, essentially.
Could you just give me those paragraph numbers again,
yes,
please?
It's paragraph 76(1)(c) to E of our written case, and paragraph 76(2) and 3 of our written case, which are page 163 to 164. And Lord Justice Stuart Smith thought that the point was important at 125 and 142 paragraphs. A couple of other points on adjudication, which have been mentioned in the course of submissions. Firstly, the suggestion was made, oh, well, there haven't been many collateral warranty adjudications, so, you know, this is an outlier or whatever, I think my learned friend said. Adjudication is a private process. You only ever hear of the ones that go to enforcement through a dispute. So there is simply no data, and the learned friend cannot give evidence as to the number of adjudications that there have been in relation to collateral contracts. The other point was, I think, the suggestion, well, the nature of the rights in this ACW were all one way. They were all obligations owed by the beneficiary, owed to the beneficiary, I'm sorry, and therefore, why would a contractor ever sign up to this? My prior point is, of course, he had to, because it was part of the overall consideration of the building contract, and if he didn't agree to that, the developer would not have invested in the project. There wouldn't have been a project because he needed something to sell to purchasers. But on the substance, it's perfectly possible to adjudicate for a negative declaration. So if there was a dispute where Abbey was saying, come back and fix these defects, you're liable, it would be perfectly possible for the contractor, if it is a construction contract, to seek a negative declaration that he was not in breach of the warranty because his work was marvellous. So it's not all one way. And in any event, I mean, I don't put this particularly highly, but there is, for example, an obligation that forgive me, let me just find it. Yes, the contract, there's clause 6.1 on page 433. The contractor grants to the beneficiary a royalty-free and non-exclusive license to use his design documents. Well, I suppose if Abbey went off and built an identical care home next door, copying the design documents, a complaint could be made by the contractor in that respect. It's not all one way, is the point I'm making. Number 7, comparison with Parkwood. All the judges in the Court of Appeal agree Parkwood was correctly decided, and there's no challenge. There was no challenge to that. Some of my learned friend's answers seem to hover on the cusp in relation to that. But the paragraphs are 58F, 160, and 141. We rely on
58F, 100.
58F. That's Lord Justice Coulson.
Oh, I see.
Lord Justice Jackson, 160.
Yes.
Lord Justice Stuart Smith, 141.
Right. Good.
We rely on the approval of Parkwood for endorsement of its key conclusion that a collateral warranty can in principle be a construction contract. 2, for the fact that the scope of that which is warranted is identified by reference to another contract, does not preclude it from being a construction contract. And thirdly, for its expression of prospective obligations being material, and that's paragraph 27E of Parkwood. My learned friends expressly don't challenge Parkwood. See paragraph 33 of their written case. The pivot of the difference in the Court of Appeal was whether the terms of the Parkwood warranty, were materially the same or different. Lord Justice Coulson felt that the differences were hair-splitting, that's paragraph 67. Lord Justice Jackson, too fine to lead to a different outcome, that's paragraph 160. Or Lord Justice Stuart Smith, differences that are striking. For what it's worth, I think I gave you the reference to the adjudicator's decision that he concluded the wording was strikingly similar to that in Parkwood. That's page 474 of the bundle. And he too noted that the ACW was drafted concurrently with the building contract and that it was a condition of the latter that the former be entered into.
Can I just ask, you took in particular 3 points from Parkwood. Have you set those out in your written case? If not, I might just ask you to repeat them for me.
I suspect we have implicitly, but I'll say them.
Would you?
Certainly, one, a collateral warranty can in principle be a construction contract. Two, the fact that the scope of that which is warranted is identified by reference to the content of another contract does not preclude it being a construction contract. And three, the expression of prospective obligations is also material. That's paragraph 27E of Parkwood. On the proper construction of the provision, we submit first and foremost, this court should construe our ACW on its own terms and not compare it with the one in Parkwood. At times, it has to be said, that was also the conclusion of Lord Justice Stuart Smith when, if I may say rather rudely, it suited. A paragraph 140, he says, on the facts of Parkwood, that was a finding that was open to him, and it does not affect the proper interpretation of the differently worded Abbey collateral warranty. So he's undertaking a comparison. And there's a passage in Mr. Walton's article, who did incidentally write this as a pupil at Keating and not as an employee of Lord Justice Coulson, or of the Court of Appeal. Adam Walton, page 1018, mentions triple point and the importance of the courts needing to distinguish between decisions which merely interpret a contract and those which lay down a wider principle. We have, in those three propositions I've put, have sought to identify the principles. When one then gets into the textual differences, we submit that that is a question of contractual interpretation. Warrants and undertakes, it was the expression used in Parkwood. And I think at one point my learned friend accepted that it wouldn't matter whether the word undertakes was in there or not. We would respectfully submit that in the case of Parkwood, it was, to use my Lord Briggs's expression, torrential drafting. It was simply the inclusion of three words that all meant the same, because essentially a warranty is an undertaking, and they are all the same in the context of the language that a warranty is a promise to do something which is of binding effect. And if one looks at the thesaurus definitions, which we've identified in our written case, you will see that they cross-refer to each other. the confusion arose, we respectfully submit, in what Mr. Justice Aikenhead said. He thought that undertake meant physically to do, and of course it can in certain cases, but in the context of this, it was equivalent to the warranty. It was giving a promise which was intended to be binding, and that's the extent of it. But what one in our submission simply can't do is to look at this agreement for its absence of a word and then find that it must mean something different. After all, what we have to look at is the word warrants, and it might in itself mean something different when it's not partnered with undertakes, and that's it's not necessary to have given each word a purpose, as Mr. Justice Aikenhead did in that case. We rely on Beaufort developments, Lord Hoffman, about redundancy. But our main point is that it's not a relevant exercise what is the relevant exercise is to look at the nature of that which has been warranted, and if it is performative in character, then it is a construction contract in our respectful submission. A warranty to continue to perform diligently your obligations is clearly a warranty to do something. Lord Justice Stuart Smith also identified some differences between the Parkwood wording on the one hand and our contract on the other. And we've identified in our written case that certainly in one of the cases, is reference to clause 3 in Parkwood, it didn't form any part of the presence of those words didn't form any part of Mr. Justice Aikenhead's reasoning for finding that it was a construction contract. So the absence of an equivalent in our contract surely can't matter.
But once the work is all done, so this whole future prospective thing actually has no application in the real world, to ask you a question I asked Ms. Day, what is the consequence, aside from whether or not it falls within section 104, of the distinction between whether it's a direct performative obligation or whether it's a warranty as to the standard of work?
There may be none, and it may be that is the value of the adjudication right is the difference, which is the consequence of you having entered into a construction.
But it would have had a value had the
dispute arisen earlier.
Had the collateral warranty been granted immediately after the building contract, whilst the works were continuing.
It always latently had that value, and it was open to the employer to call for its production and execution at any point when the dispute arose. That's the point. You sit there, you don't have to have it in your hands, but the moment a dispute arises, whether it's during or after, you can insist upon its production. I wanted to move to availability of injunctions and specific performance. I hesitate to call him my junior because he isn't anymore, but Mr. Owen already highlighted the point that this is about locus. The fact that sometimes it is difficult to get specific performance of a building contract in injunction and specific performance proceedings is a neutral. The question is, because those are problems that the employer faces, and the employer unequivocally has entered into a building contract. So the question here is not about how difficult it might be. The question is this obligation, is this contract of a type that the parties might have envisaged would be capable of being ordered by interim proceedings to be enforced. Now, Lord Justice Stuart Smith said, and Lord Briggs may have come to a similar view, that that's a consequence of it being a construction contract, rather that you have the right to adjudicate, that you have a right to. The consequence of it being a construction contract might be that you have those interim remedies. It's not a reason for it. But where you have obligations in the collateral warranty, and I'm including for these purposes the ones that you were taken to, those are precisely the sorts of obligations that you would expect to be capable of specific performance. They're not difficult. They don't involve superintendence by the court in the way that performing recommendations on the building contract would. The right to inspect the work. So the contractor's busy putting in his asbestos, which is all prohibited. You can't come in here, Gov, I'm not showing you. And we want to come in and just see if that's what's going on. There's no reason at all why a court in favour of the employer wouldn't give an injunction allowing, or a specific performance allowing the employer in. No difficulties there. And the question simply becomes, well, was that a type of right that was one that should be made available, to us? The other point is it wasn't the absence of the right to specific performance or an injunction. What didn't stop the conclusion in Parkwood that Parkwood was that the Parkwood warranty was a construction contract, and of course there is no appeal against the correctness of Parkwood. So, in our submission, this point doesn't. The point that specific performance is difficult to obtain is irrelevant. What matters is the lockers, But that said, we do submit that and we've given you some articles and some pointers, that actually the notion that the court won't specifically enforce building contracts is somewhat overstated. It becomes a question of fact and degree. There's a case called Blue Manchester which says it all depends. Lord Burroughs' book on remedies also says the tide has turned in that respect. And the Building Safety Act, which has recently been enacted, can require the court to, or allows the court to make a remediation order in respect of the carrying out of building works. Also useful to compare with a party who holds rights under the Contracts Rights of Third Parties Act, different from our case, but a party in that position is entitled to exercise any remedy, that's section 1, subsection 5, which means that they could go, a holder of third-party rights under the Act has the facility, the locus, to go to court for a specific performance. And all of this is important because it shows the nature of the right is contemporary with the carrying out of construction operations. So if where we part company with Lord Justice Stuart Smith is that if the nature of the rights which have been given to the beneficiary are of a type which necessarily are ones for the benefit of which lies in the concurrent enforcement of them, rather than in a retrospective claim for damages for breach because the warranty turned out to be untrue, that would be an indicator that it was a carrying out of construction operations. We commend to you the article of Mr. Walton. It's a thoughtful article, and there's a lot of good material in it. I can't take you to it for want of time. So far as the Manual of Construction Agreements is concerned, which my learned friend relied on, if I start by saying, until this case, I'd never heard of it, it's not exactly a mainstream text. I think the court has already picked up that it's a slightly odd document because it doesn't appear, in all respects, to be updated with the consequences of of indeed this case. It seems to be recording the point about the date of execution as having some materiality, and then you have to read on to find, oh, well, no, it doesn't now because of the Court of Appeals decision. It's like a sort of rolling document. The author self-confesses to having had the initial view that Parkwood was wrongly decided. And of course, before this court, that isn't the position. Parkwood was correctly decided. And so there's a sense of an echo chamber in perhaps endorsing the views of Lord Justice Stuart Smith. The reason we submit why a number of people in the construction industry were puzzled as to how it came to be that a collateral warranty could in principle be a construction contract is because one of the functions of the Housing Grants Act was to introduce the mandatory provision in respect of payment. There's a number of clauses which you've been happily excused from having to read about an obligation in every construction contract to have a series of payment provisions. But there's a light touch given to that, which is the contract can set the number and time and scope of those provisions, and provided it does that, the court doesn't say they have to have a particular regularity to them or particular quantum attached to them. And part of the case below had been that this document can't be a construction contract because it doesn't provide that flow of interim payments. But as you will see in the Court of Appeal's decision, that was pretty much abandoned by my learned friend Mr. Gregorio because there is a payment provision in this collateral warranty, which is £1, and it is accepted that that suffices to get over the minimum criteria threshold that the Act requires of a construction contract. So that key point was one which the industry hadn't quite latched onto. But once it's understood, and there's no challenge there, Maloney and Friends started to talk about the essential ingredients of a construction contract as having payment provisions. Well, this one does, and by common consensus, it meets the requirements. So that is all that is necessary. So therefore, there's nothing we submit in that document, or that article, which I have never heard. That touches on the definition of a building contract, which played a part in the broader question of four. You remember there was the modern engineering and Gilbert Ash definition. That we submit really has no part to play here. Firstly, because if Parliament had wanted to use the word building contract, it would have used the word building contract with a small c, a small b and a small c. Instead, it created a statutory definition of what constitutes a construction contract, and therefore one has to look at that. Secondly, the definition of the conventional modern building contract in modern engineering was because there had been an argument in that case that building contracts were subject to different rules from other contracts for the sale of goods and so on in respect of the law of set-off. That was the context of it. It was all about Mondale and Steele and all the rest of it. It was in that context that the law of what was described as a conventional building contract was identified. That's not the sort of issue that arises here. Indeed, quite the reverse. The section of the Act prescribes how you deal with set-off in the provisions for notices, sections 110 and 111. So, in my submission, this court does not get any assistance from what is a conventional building contract. It's just irrelevant. The other point, of course, is that the definition of the conventional building contract in modern engineering included the provision of interim payments. And as I've just indicated, this is a matter which is now the subject of regulation, and they don't need to be instalment payments. They can be just one payment of £1. The essence of, I think the essence of Malone and Friends' submission was that what stopped this from becoming a building contract, a construction contract, was the absence of direct obligation. And that simply becomes a question of construction. Is this a direct obligation which is owed to Abbey? And the majority of the Court of Appeal rightly concluded that it was. And that is, and if it was, then it is a contract for the carrying out of construction operations. One doesn't need any particular breadth. As I said earlier, that was a debate in a different context. It is simply a question of whether the obligation is owed. And at times, with due respect to my own friend, I really didn't see on which side of the line she fell in relation to the arguments. And that is, we say, revelatory of the difficulty. One simply has to ask, is this a performative obligation owed to Abbey? We say it is on a proper construction. If it is, it's very straightforward, then it's a construction contract. And this notion that a warranty is simply a statement of fact or outcome that only is triggered at the end of the project. Of course you can have such an agreement, and that wouldn't be a construction contract, but that's not this case. I've probably got a number of other matters that I... there's perhaps just one point which I will mention. It's this. Insofar as breadth has any part to play in this debate, and for all the reasons I've said, I submit that it doesn't, we do say that the court can take account of the purpose of the Housing Grants Act. And my Lord Briggs dealt with that in the Bresco case, where you indicated that adjudication was designed to be a mainstream dispute resolution mechanism in its own right. And you quoted Mr. Adam Constable and a decision of his, now Mr. Justice Constable, who talked about the breadth of the statutory scheme, which was good for the administration of justice. In other words, unlocking payment and cash flow was one of the aims of the Act, but the other was this creation of this mainstream dispute resolution in its own right, good for the administration of justice. These are not beneficial byproducts or after effects that have come to be appreciated. They are within the scope of Parliament's original intention. And there is no reason, therefore, why the benefit of that system, that regime, should not extend to anybody who is interested in the execution of works and who, for whatever reason, becomes embroiled in a construction dispute in relation to it. In other words, to quote Mr. Walton, the approach of the majority furthers, this is page 1018, furthers one of the main objectives of the Act to improve dispute resolution mechanisms within the construction industry. So it has a purpose, giving effect to the purpose, and that is a purpose which my Lord Briggs recognised in Bresco, paragraph 12. And the focus I place is on, if I may say respect for your words, adjudication was designed to be a mainstream dispute. This is not an afterthought, hello, hurrah, this is marvellous, whoever thought it. That was the intention, and therefore giving it that purposive construction might inform the way in which you treat the ACW of this type. Indeed, I think that is anything else? I'm done. Thank you very much.
Thank you very much, Mr. Nissen. Ms. Day.
One might ask, given the nature of the discussions we've been having, how anyone on the ground is supposed to work out what is a construction contract and what isn't. And I do ask you to take a step back. We've spent now nearly a day arguing about tiny words here and there. The tenant, that one is within the Act. The funder isn't. Sorry, the funder is, the tenant isn't. Is that really what Parliament intended? we've set out in our written submissions the approach to statutory interpretation, and I'm sure you're all very familiar with, which is why I didn't go to it orally. Yes, you can apply a purposive interpretation, but that doesn't mean you constrain the natural meaning of the words. So we say that the starting point is, what do these words mean for the carrying out of construction operations? And it was very telling when you asked, what's the difference between for and in respect of? You were told that they mean the same thing. And with the greatest of respect, you don't need a dictionary, you don't need anything. They plainly do not mean the same thing. And in the court below, there was a submission made to the Court of Appeal that if it looks and smells like a construction contract, it is if it isn't. And that was brushed off. But in fact, there is a problem here. The fact we're having to spend a whole day trying to work out whether this is or isn't shows that there is a difficulty. We also say that you shouldn't stretch the language of the statute in order to change the meaning of construction contract. There's a simple way around this, which is that adjudication provisions could be put in. In terms of the desirability of adjudication, again in Bresco, we haven't had time to go to it, but there's obviously a very clear exposition there of why the Act was introduced. And in my submission, we are getting a very, very long way away from why it was introduced. Paragraph 12 of Bresco, page 724 of the bundle, sets out that one of the main reasons was to ensure improvement of cash flow. Pay now, argue later. And that was particularly where you had subcontractors and sub-subcontractors on a project. So you asked me earlier, and I couldn't answer straight away, what other kinds apart from employer and contractor? You obviously have contractor and subcontractors, or subcontractors and sub-subcontractors that will be covered. You can have clients and professional consultants. You can have contracts that are assigned. You can have novated contracts. None of these come anywhere near being what this sort of agreement is. The definition in this court, in fact, now appears different to the one in the Court of Appeal. So the definition comes down to something that's performative, and I'll come back to that. But the test in the Court of Appeal is the narrow test that Lord Justice Coulson set out at 30 and 31 of his decision. It's page 187 of your bundle. And these two paragraphs are the only paragraphs that Peter Jackson agrees with. So at paragraph 163, he says, I agree with the short version of Lord Justice Coulson. He doesn't then endorse what follows from Lord Justice Coulson in relation to this question. But I'd ask you, after the discussion that we've had today, to look back at 30 and 31 very carefully. 30 obviously says that it won't be a construction contract within the meaning of the Act, where it doesn't recognise or regulate the ongoing carrying out of any future work. So that isn't within the Act. 31 then says what may be within the Act, although I emphasise the use of the word may, because it seems to be up for grabs in every case, is this: a promise which regulates, at least in part, the ongoing carrying out of the construction operations. And one of the useful purposes in my submission of what you've been treated to this afternoon in terms of looking at the different kinds of warranties, the different amendments that are made, is that the agreement in this case doesn't in any way regulate the ongoing carrying out of construction operations, because the beneficiary has no control over how those are carried out. So even if the majority were correct on this, in my submission, our appeal should succeed. But again, as I've submitted to you, that shouldn't be the test. And one just needs to look at those words, which regulates, at least in part, the ongoing carrying out of construction operations. The collateral warranty does not do that. In terms of the use of the word performative, in my submission, that isn't a satisfactory test. This is a promise to perform another promise. And that cannot be a construction contract. The word performative could, in effect, apply to any promise. And if we look at Lord Justice Stuart Smith, page 204, paragraph 109, this is where he explains that breach of warranty is conceptually different, and it rests upon the fact that warranting a person's promise is found to be broken. And then if we look at page 205, at the end of page 209, he says this: one of the instances of a warranty is that an injunction will not lie to enforce the underlying obligation. The only question is whether the person's warranty is shown to have been broken, which opens the way to a remedy in damages. 110, he explains that there could have been an ovation, there could have been direct rights given, but the purpose of the collateral warranty, as he emphasises at the end, referring back to a judgment of Mrs. Justice O'Farrell in Swansea, is to provide a direct right of action by the claimant against the second defendant in respect of its obligations under the building contract to which the claimant was not a party. That is all it does, and therefore at 111 he correctly sets out in my submission that what clause 41A is doing is simply warranting, that's the word used, promising that it has performed and will continue to perform diligently its obligations under the contract. And so,
sorry, with the Swan one,
Swansea,
sorry, where Mrs. Justice O'Farrell said that that was the purpose of the collateral warranty, did that mean it was or it wasn't a construction contract?
well, it's not. It's providing a direct right of action where
Yes.
you wouldn't have one because of Murphy and Brentwood.
Yes.
It isn't providing any direct rights into how the building contract is regulated or performed. There's a right to claim damages, but there isn't a right to influence or alter that. And indeed, the provisions you were taken to in the building contract rather illustrate that. Those provisions that were put in as a matter of agreement, they're not linked in my submission to the collateral warranty. They're about access. Obviously, third parties who have rights don't have the right to adjudicate. But they really illustrate that this agreement we're looking at is not a construction contract within the meaning of the Act. And the spectres raised of a funder, it's said to this court, well, look, the funder can come along and adjudicate. In my submission, that would be a terrible position if that's allowed to happen. One can imagine that that could be used by funders to disrupt building contracts. Adjudication has many benefits. It also can be used tactically, as Mr. Owen accepted. It has good and bad points. Imagine a funder who decides to launch an adjudication, gets his rough and ready justice, gets his decision that there's a problem with a building, the contractor has to pay, and then the whole project goes under, and the funder has achieved through adjudication something that in my submission should not be possible to use adjudication in that way. When one looks back and looks at what adjudication was intended for, as set out in Bresco, it is not that. It has two parts, adjudication and payment, for a reason, because one of its big aims was to ensure prompt payment of disputes so that buildings could be completed. In terms of the point that you heard about timing, if we can look at paragraph 65 of the Court of Appeal judgment, the way in which timing was used, and we say it is still relevant, is in considering whether this distinction, it's page 194, paragraph 65, where Mr. de Gregorio ran an argument that it was artificial to differentiate between the past and future in circumstances, whereas here the warranty was signed long after the works had actually been completed. And that's dismissed. But that's the sense in which timing in our submission can be relevant. It reinforces, it's not the sole reason, but it does reinforce the artificiality of the distinction that the majority was seeking to draw between warranting a past state of affairs and warranting a future state of affairs, which they said amounted to a regulation of the building contract. Or, as my learned friends put it in this court, transforming it into a performative obligation. We say it's neither of those things. If I can just take you very briefly to the warranty to the tenant, just to draw your attention, it's 1063 to a part of that that you were not taken to, clause 2.
Sorry, what document is this?
This is the warranty to the collateral warranty to the tenant in standard form.
And this is the pro forma which was not used.
Correct. But this is part of Mr. Nissen's submission of the pro forma for the warranty to the funder is a construction contract. The pro forma of the warranty to the tenant is not. If you look, for example, at clause 2 of this pro forma, you will see that that actually does contain words relating to future performance. It's identical, actually, to the one that we find in our agreement. That's the warranty about materials. So that obviously says that the contractor warrants that he has not used and will not use materials in the works. Now, I just draw your attention to that because this is said, well, this is all just about past performance. And yet when one starts reading the words of it, we see that there is actually a promise given, a warranty given in relation to future performance. And in my submission, this court should not be encouraging this sort of dissection of agreements, turning on phrases such as has been suggested. We need to have a clear rule. Parliament did not intend for these to be part of the adjudication regime. And during the course of argument, it was also discussed that adjudication could be a bad thing. And in particular, again, if this is permitted to be the decision, then you will have conflicting adjudications about the same thing. So obviously when you're dealing with contractor-subcontractor disputes and, say, employer-contractor disputes, you might have things that overlap. But here we're talking about conflicting adjudication decisions in relation to the same contract. So not the employer, contractor, subcontractor, different contracts. You'd actually have conflicting decisions potentially on the same contract. The clauses in the main contract you were taken to, I'm not going to spend a lot of time on those. Those are really about access. They don't assist in relation to any of the issues that you need to decide.
Well, is this a possible scenario? Sorry. We have the collateral warranty template that's attached to the building contract, and we know that that can be entered into at any time during the course of the works or after the course of the works. There are some clauses in the building contract which the beneficiary, if that beneficiary comes onto the scene during the course of the works, might want to use, and they've been included for the beneficiary's benefit. And Mr. Nissen says, or Mr. Owen says, it needs, the collateral warranty is the mechanism by which access to the site can be enforced. But the collateral warranty might also be entered into at a much later time when there's no question of those access being considered, and those clauses for that purpose are redundant. And then the question is, looking at the collateral warranty, which refers to future work, perhaps for use in the context when the collateral warranty is entered into during the course of the works, do we then just treat those as they should have been crossed out, but they weren't crossed out for this particular agreement? Or do we imbue them with some other intention, which is they are put there to make it clear that this is still a performative obligation for the purpose of deciding whether this is a construction contract within the meaning of Section 104. Now, what I'm not clear about is whether a possible scenario is that it is a construction contract if it's entered into at a time when those provisions of it are needed to enforce clauses like the clause about getting access to the site. But if it's entered into once those clauses are spent or are not relevant anymore, then it's not a construction contract. Or does it have to either be one or the other whenever it's entered into?
Well, in my submission, that rather illustrates why we shouldn't be going down this route of dividing things up according to time. So if it's a past obligation, it's not a construction contract. If it's a future obligation, it is, which is effectively, I think, where we are. The provisions in the main agreement is a real red herring, because the only reason that you need the collateral warranty is because the third-party rights were excluded. But of course, if the third-party rights had remained, then there would be no right to adjudicate. So in fact, by having the collateral warranty, if you accept these submissions, you're putting the beneficiary in a better position by reason of the third-party rights coming out and obtaining that via a collateral warranty. It just makes no sense at all, because you will recall that there's the case that says third-party rights such as that can't adjudicate. It's very important not to lose sight of what we're focusing on here. We're not trying to shut out the right to adjudicate. It's simply what contracts must contain an adjudication provision. And we're tying ourselves in knots to try and get to the end goal, which is adjudication is a good thing. All contracts should be dealt with in this way if they concern defective buildings. That shouldn't be the driver. The driver should be, the starting point is actually looking at the words in the statute. Then if those are unclear, looking at the purpose. But the purpose is rather the purpose as perceived, because in my submission there are also disadvantages to having adjudication here. But the question of what Parliament intended, we're very, very far away from that at this point. And you will have a situation where those third parties with rights under a contract cannot adjudicate, but people who have a collateral warranty will be able to. And in my submission, that would be both unfortunate, but also not what Parliament provided for. And again, I would commend you to go back to the words of the statute, which I note that you weren't taken to by Mr. Nissen because he says it's not in dispute. With the greatest of respect, there is a difference between us as to what those words mean within the statute. And certainly the Court of Appeal, the majority and the dissenter, had a very significant disagreement as to what they meant, and indeed all three members of the Court of Appeal felt it meant slightly different things. So it is very important to have that and to proceed from that. Very conscious of time.
You're up against it.
Yeah, two things about Parkwood. Just, it said on the one hand it's right, and then it said you should reject Mr. Justice Aikenhead's reasoning. The reasoning is fundamental to the outcome, and that is that he says undertaking means to do, warrant doesn't. And I would again just ask you to look at paragraph 138 of Mr. Justice Stuart Smith's, Lord Justice Stuart Smith's judgment, the three reasons why he distinguishes Parkwood. It's page 213 of the bundle.
213.
213. Apologies, we're a couple of minutes over. I also wanted to say from all of us, thank you for sitting an extra half an hour earlier today to accommodate us. Obviously, the date had to be moved, and we hadn't realised.
I understand that, and you.
So thank you. I'm sure it's
you were right to ask because we've needed it.
Could I just say, I'm not going to open the argument, but it is important. I know we've spent a lot of time on the date of execution point. Just to draw your attention to paragraph 33 of Malone Friends' appeal, that abandons that.
Yes, we understand that.
And endorses paragraph 88 of Lord Justice Stuart Smith, who says, I also agree that the date of execution...
No, we do understand. You've not been asked to make submissions against its unabandonment. Yes, well, thank you both, all your supporting teams, including Mr. Owen, and those behind who have no doubt played a major part in the preparation of all the written materials, for stimulating debate about which we will go away and think hard and deliver a judgment or judgments in due course.